Hello and welcome to NewsX. I am Shambhav Sharma. We are recording here a very important special segment called Reporter's Diary. Here we'll talk about important judgments of the Supreme Court in 2024. That's why we are recording it from outside the top court of the country. I'm joined by advocate on record in the Supreme Court, Advocate Ashwini Dubey here. We welcome you here to this conversation, sir. And we'll talk about judgments like Bulldozer Justice Judgment, Madarsa Act judgment, and the Supreme Court's very important judgment where Supreme Court dismissed the petition demanding to scrap socialist and secular word from the Constitution of India. And we'll start this discussion, Ashwini Saab. Let's talk about this Bulldozer Justice judgment of the Supreme Court, where the top court has come down heavily on the states for misusing its power vested by the Constitution, vested by the law of the land, where Supreme Court has criticized the government to an extent that they cannot misuse their power in the name of Bulldozer Justice. What's your take on that?
Yes, Honorable Supreme Court very candidly in its judgment have ruled that merely an involvement of a person in a criminal case does not permit the authorities to bulldoze his house without following the due process of law. Certain guidelines were formulated. One of the guidelines is that since he is an accused, it does not mean that the house which is belongs to him is an illegal house. Number one. Number two, so the Supreme Court says if you have the right to demolish it as per the municipal laws, but for that you have to give the notice, and if it is unauthorizingly made. So merely an accused, even merely conviction, unless and until there is a proof, there is an evidence that that property has been built either through the crime money receipts from the crime, or that has been built on an authorized property.
Even the money received from the proceeds of crime, or even even a person is convicted under certain laws, still the house of that person cannot be demolished on these grounds.
Yes, that's what Supreme Court has says, that since the person's involvement does not give you right to demolish it, but the Supreme Court at the same time have very candidly also ruled that if it's an encroachment, and if it is on a public land, if it is on a road, then authorities are empowered to demolish it. Third thing, the Honorable Supreme Court very rightly said that for demolishing or bulldozing any house, you have to serve the notice. 15 days notice, there is various ways to serve the notice, and then everything is to be recorded. Right to appeal, which is a fundamental right, that should be given, time should be given, and if authorities violate those guidelines, then authorities will have to pay and face the consequences for taking any action if the guidelines are not followed for demolishing a house. Meaning thereby it is clear that merely involvement of person in a criminal case does not entitle the authorities to bulldoze the house. It's a very significant and good judgment.
Yes, and also it catch the headlines of the newspapers, and it was reported widely in the country, and people also applauded this judgment of the Supreme Court. I'll also talk about another very important judgment of the Supreme Court, where Supreme Court has dismissed the petition where the petitioner has demanded to scrap the two words socialist and secular from the Constitution of India, because the preamble, as Nani Palkiwala once said, is the identity card of the Constitution of India, and there are two words, socialist and secular, added by 42nd Constitutional Amendment Act 1976. So there was a petition filed in the Supreme Court demanding to scrap these words from the preamble of Indian Constitution, and Supreme Court has dismissed this petition. We'll discuss about this as well. What was this case in the Supreme Court?
The petition PIL was filed by Mr. Ashwini Upadhyay, Mr. Vishnu Shankar Jain, Mr. Subramaniam Swamy, and few other individuals, saying that the 42nd Amendment, which was carried out, the constitutional amendment, that violates the basic structure of the Constitution as has been laid down Keshwad and Bharti case. This is one. The second, it has said that the preamble cannot be changed. So the 1976 amendment, where the two words, the socialists and seculars, have been added, those should not have been added. And 42nd amendment, most of the amendments, the decisions taken during the 42nd amendments have already overruled by that that time the subsequent government. But the Honorable Supreme Court says 2 points are very important, that the socialist and secular exist in this country from centuries back.
Right.
Now the Supreme Court second says that so far as the socialist and secular word is concerned, after various judgment of the Supreme Court, that has become part of the basic structure of the Constitution. So Honorable Supreme Court has dismissed those petitions, saying that even if it is not incorporated earlier, and even if it is incorporated in 42nd Amendment, then also it has become the part of the basic structure. And that not only this, the Supreme Court's the observation is very significant, that the secularism and socialism existed centuries back in this country.
Right,
So
right.
that is very significant judgment.
And let's talk about Indian secularism for a bit. Indian secularism is different from Western secularism.
Yes, the Honorable Supreme Court has also said that this secularism of India is different from the Western countries.
Right.
So it is not that this constitution was brought into effect in 26th January 1950 and the word was added there. That does not mean the secularism, Indian secularism is different from the Western secularism, and it is existing from centuries back. So significant judgment, good judgment, and I think that in years it will be followed.
Correct, absolutely. And also this socialist term in Indian constitution, although it was not there before 1976, but let's talk about the Indian polity a bit. Indian polity, do you think is socialist in nature or a welfare state model, or which kind of Indian polity is currently, or rather it depends on the regime to regime? When it was a Congress's time, it was different policy, and now it's different.
See, the socialist, if you see in a political meaning or political context, if you see the socialism, before 1976, there was a party, Socialist Party.
Correct.
So it is not that a word was added in 1976 by its 42nd Constitutional Amendment. The socialism came from that day. The socialism was existing. Even prior to the independence of this country, socialism was existing in this country. Earlier, centuries ago, you will say socialism.
Janpads, Mahajanpads were there.
Janpads, even the Chanakya's time, you will see that time it was existing. Likhvi Ganaraj, if you will see the socialism was existing. So the Honorable Supreme Court has clarified this aspect, number one. Number two, of course, indeed, a country, if you read the Constitution, the Constitution says that the government should take all the decisions in the larger interests of the country, and it's a welfare state. So any decision taken has to be seen in the light of that. So word socialism existed in the country, and it was added in 1976, which has given further strengthened it.
Or rather clarified that India is a socialist and a secular country apart from democratic republic, which it is. Right. Let's also talk about a very important judgment of the Supreme Court delivered in February, Electoral Bond Scheme. And I want to understand it from you for our viewers. It was very surprising the way Supreme Court has come up with this Electoral Bond Scheme and has clarified things further.
This Honorable Supreme Court, see, one of the moot question before Honorable Supreme Court was that whether the right to know of a voter or a citizen is its fundamental right or not. Does a citizen of this country has right to know that which political party has received the funds or the donation from which industrial house, because that will depend on the policies formulated by that particular state or country. If more and more money is given in the form of donation to the political parties, of course political parties will show some inclination towards framing policies for the welfare of those industries. So that was the issue, and Honorable Supreme Court has very candidly, while taking in the constitutional framework, have said that the citizens have a right to know that which political party has received donation from which industry or which individual, and that is what. But if you will see the basic concept of electoral bond, that was also very much, 42 banks were given the right to just issue the electoral bond that was being deposited, and it was also an option, the effort to eradicate the black money.
And Mr. Dubey, see, the transparency is very important in a democracy, and for the functioning of democracy, elections, free and fair elections.
That is the moot court.
Yes,
That is
yes.
the Representation of People Act also says. That is, if you
Absolutely,
see the basic fundamental rights of the basic object of the Constitution, you will see the free, fair, impartial election is the root of the Constitution. And to have a healthy and democratic government, you have to have a fair, free, impartial election, and that too which is beneficial to the citizens of this
Citizens of the country.
Yes, that's
absolutely.
all. So this judgment is also very significant judgment, and the Honorable Supreme Court has really stood as a savior of the citizens of this country, as rightly said, जनता का जनता के लिए जनता के द्वारा. So Honorable Supreme Court has shown it
Absolutely.
it's in a true letter in spirit.
Absolutely. So this was Advocate Ashwini Dubey. He clarified things at large, and we shot it this reporter's diary segment from outside the Supreme Court with video journalist Avdesh Sorasia. This is Shambhav Sharma for NewsX.